In William Shakespeare's Richard II, the protagonist had remarked, he had 12 disciples and was betrayed by one. I have 12,000 citizens and find a friend in none. But in the end, even he resolved that you may my crown and state depose, but my griefs still am I king of those. 1966, ironically the year in which I was born, a Sunday child and a Capricorn with a Taurus rising, for those who follow astrology, was a groundbreaking year for progressive causes. The Planned Parenthood of New Jersey office in Mercer County, New Jersey, announced a record-breaking count for abortions in their abortion mill located in the predominantly black city of Trenton, which they heralded as a victory in the fight against a population explosion. It was the year in which the United States Supreme Court, in a majority opinion drafted by Justice Stewart, decided the case of Georgia v. Rachel, involving a removal petition filed by Thomas Rachel and 19 other defendants seeking to transfer to the United States District Court for the Northern District of Georgia criminal trespass prosecutions pending against them in the Superior Court of Fulton County, Georgia, because of their civil disobedience activities in the city of Atlanta in 1963, attempting to integrate lunch counters, like the ones that former Congressman John Lewis did in what has often been described as good trouble by progressives. It was an important case of first impression that tested a century-old federal law enacted in the Civil Rights Act of 1866 by radical Republicans, where the court applied the new provisions that had amended the statute in the Civil Rights Act of 1964, and where the United States Supreme Court considered a retroactive application of the new law, changing the decision maker on the issues as to whether any discrimination had occurred in the prosecution of the case from the state court judge asking himself if he was prejudiced, deciding the criminal action to the federal district court judge, who could make the determination as to whether there was sufficient evidence of discrimination in violation of civil rights to acquit the defendants. While that progressive court did in fact recognize the provision, the petition for removal to federal court of the criminal action was denied on other technical grounds. But in a case brought to the federal district court for the Eastern District of Virginia in the progressive city of Alexandria in 2018, in a case involving a trespass in the second busiest abortion mill in the Commonwealth of Virginia, responsible for over 2,200 abortions per year, primarily single, poor women. That court decided that the law did not even exist, while the circuit court for the city of Alexandria, in violation of that law, went forward to convict the defendant in absentia while the petition was pending a decision in the federal court, stating as a reason that the prosecution had waited at least 45 minutes at a trial to which the defendant had failed to appear, a trial to which he had not even been summoned to appear. And in the year 1966, a case with which many are at least vaguely familiar through television programs and films, was decided by the nation's highest court in an opinion drafted by Chief Justice Earl Warren, who had written a majority decision in the landmark case of Brown v. Board of Education for Topeka, Kansas, where he had noted famously that education is perhaps the most important function of state and local government. Words ominously foreboding in a pandemic crisis that has even closed the doors of schoolhouses and libraries and Sunday schools. And in that 1966 decision, Miranda v. Arizona, he wrote, "The cases before us raise questions which go to the roots of our concepts of American criminal jurisprudence. The restraint society must observe consistent with the federal Constitution in prosecuting individuals for crime. More specifically, we deal with the admissibility of statements obtained from an individual who is subjected to custodial police interrogation, and the necessity for procedures which assure that the individual is accorded his privilege under the Fifth Amendment to the Constitution not to be compelled to incriminate himself." That progressive Chief Justice continued, "We dealt with certain phases of this problem recently in Escobedo v. Illinois, 378 U.S. 478, 1964. There, as in the 4 cases before us, law enforcement officials took the defendant into custody and interrogated him at a police station for the purpose of obtaining a confession. The police did not effectively advise him of his right to remain silent or of his right to consult with his attorney. Rather, they confronted him with an alleged accomplice who accused him of having perpetrated a murder. When the defendant denied the accusation and said, 'I didn't shoot Manuel, you did it,' they handcuffed him and took him to an interrogation room. There, while handcuffed and standing, he was questioned for 4 hours until he confessed. During this interrogation, the police denied his request to speak to his attorney, and they prevented his retained attorney, who had come to the police station, from consulting with him. At his trial, the state, over his objection, introduced the confession against him. We held that the statements thus made were constitutionally inadmissible." This case has been the subject of judicial interpretation and spirited legal debate since it was decided 2 years ago, the court continued. Both state and federal courts, in assessing its implications, have arrived at varying conclusions. A wealth of scholarly material has been written tracing its ramifications and underpinnings. Police and prosecutor have speculated on its range of desirability. We granted certiorari in these cases in order further to explore some facets of the problems thus exposed of applying the privilege against self-incrimination to in-custody interrogation, and to give concrete constitutional guidelines for law enforcement agencies and courts to follow. One of the primary concerns of the High Court in the Miranda decision was the great potential for an accused defendant who had been placed in isolation and subjected to undue influence of extortionate proportions by law enforcement officials, who held a decided advantage in procuring what may have been a false confession, tantamount to the concerns raised by those subjected to coercive interrogation, who might simply say anything if only to be relieved from the imminent threat or fear of a threat of death or grave bodily harm. And these same concerns regarding a taint to the legal process are timely at a time of intense emotion, when the nation is greatly divided in corruption of a fair and impartial trial on the merits of persons who have been accused of what has been described as heinous and indeed insurrectionary crimes. And just like those authors of proper email etiquette often advise a person to take a time out before hitting the send button after composing a passionate email, certainly any reasonable person would advise the same caution, if not more, when treating matters of serious crimes with more severe consequences, both to the individual standing accused, but also to the cherished traditions of a free nation. This right against self-incrimination is not available to litigants engaged in controversy arising under civil law. And those familiar with blockbuster films like A Few Good Men may well recall the actor Jack Nicholson portraying the role of Colonel Nathan Jessup, quipping boldly the line, "You can't handle the truth," while breaking under the pressures of questioning by the JAG attorney, Lieutenant Daniel Caffey, portrayed by Tom Cruise, who immediately requested the court to convene an Article 39 inquiry on the grounds that the accused might further incriminate himself through his passionate testimony, and reminding the court, that court of law and justice, that even the accused has rights in a rule of law. And the present COVID-19 response litigations involving both state and federal courts, in which Drs. Ralph Northam and his Chief Medical Officer, Mohammed Norman Oliver, as well as implicating their appointed counsel, State Attorney General Mark Herring, have chosen a peculiar method for their defense stratagem that raises reasonable suspicions regarding their potential election to exercise a right to remain silent, not available to a litigant brought under the personal jurisdiction of any court, state or federal, in a civil matter. As stated in Spinelli, Callahan, Berkman, S.A.V., Imas, Gruner, AIA, and Associates, a case arising under the federal racketeering statute in the federal district courts of Maryland in 1985, at least 3 different standards of proof are within the realm of possibility. Proof beyond a reasonable doubt, the burden of proof in any criminal matter, proof by clear and convincing evidence, and proof by a preponderance of evidence, which is often described by litigators as evidence that amounts to more than a scintilla, or even more than an iota, citing the case of Anderson v. Liberty Lobby Incorporated, a U.S. Supreme Court case decided in 1986, and clarifying for all matters while citing to the decision of the U.S. Supreme Court, the Sixth Circuit in U.S. v. Graham articulated clearly that the rule that at a minimum the evidence should be clear and convincing, if not beyond a reasonable doubt, as tried by a jury of impartial peers, involves a punitive sentence involving offenses under criminal law for each and every element of the crimes of which a person is accused, a rule that would even reach any article of impeachment for alleged high crimes and misdemeanors, at least under a rule of law. And there is no genuine issue of material fact on all evidence of record beyond a reasonable doubt that Drs. Northam and Oliver did in fact evade service of process from both the sheriff for the city of Alexandria and the United States Marshal in civil litigations brought against the preventative measures that they had imposed, including a state lockdown specifically advised against by the World Health Organization that had issued the pandemic declaration on March 10, 2020, just days before they proceeded ahead with a plan that within just 1 week resulted in unemployment claims skyrocketing over tenfold, from around 4,000 to over 46,000 at a time when Dr. Oliver had declared the state at a low state of risk. An evasion of a summons, especially by a United States Marshal, is a felony, punishable by up to 20 years in prison. There is no genuine issue of material fact on all evidence of record beyond a reasonable doubt that Drs. Northam and Oliver did in fact ignore the guidance reiterated 3 times in the largest tracer contact study completed before the lockdowns to protect the elderly in nursing homes. Advice they even ignored through months of litigation, guidance which had specifically directed them to publish resources to follow to protect that most vulnerable population that today represents over half of the over 5,000 fatalities to a novel coronavirus. That report had stated in plain and clear English was not, on all evidence, after review of over 55,000 laboratory-confirmed cases and their tracer contacts of contagious disease, at all, but rather finding a significantly high correlation between incidents of infection and the specific locations, evidence highly suggesting the deployment of a biological weapon of terror. And in that instance, the farming population in the largest city in the central mainland of China, the political opposition in a city pressing to transition from a primarily agrarian economy to a technological and industrial one, and a city that had already begun to emerge out of the lockdowns after only 1 month. There is no genuine issue of material fact on all evidence of record beyond a reasonable doubt that Dr. Northam has publicly conceded during his Labor Day COVID-19 update his belief that the pathogen, which on all clinical evidence is not as he described as highly infectious or contagious, is being transmitted primarily as an aerosol, which would require a 5% infectious pathogen to fill the breathable air in an enclosed space, on all evidence, for up to 1.5 hours, which could only be the result of a deployment of a biological weapon of terror. There is no genuine issue of material fact on all evidence of record beyond a reasonable doubt that Drs. Northam and Oliver know or should know that both coughing and sneezing to a physician connote a specific technical understanding not often understood by the general public, who had to be explained through cartoons how to wear a facial covering in a public health threat regarding a respiratory tract infection pathogen as asymptomatic presentations of potential disease condition, often created through the natural human immune responses of persons attempting to repel the invasion of a foreign contaminant. But he has used, or rather exploited unconsciously, the ignorance of the public to promote his policies by creating fears about what has been termed as asymptomatic spread of infection, describe this person somehow infecting others while unaware that they are infected or ill. But all people know something is wrong when they start to sneeze or cough. There is no genuine issue of material fact on all evidence of record, beyond a reasonable doubt that Drs. Northam and Oliver know or should know that a necessary precondition for a superspreader event is the presence of a pathogen that is at least validated as highly contagious, or at least possessing a 60% secondary attack rate against tracer contacts, which not even one large or small sample size tracer contact study to date has yet validated. And moreover, in what can only be described as willful blindness, both Drs. Northam and Oliver did engage in what has at least been grossly negligent conduct, failing to even begin to equip their medical staff to conduct tracer contact follow-up until over a month after the first infections were reported, and over 2 months after Dr. Oliver had stated in public record that he had begun to monitor the progress of an emerging public health threat. As reiterated by the 8th Circuit, in the case of Lutheran v. U.S. in 1937, mere acquiescence or silence or failure of an officer to perform a duty does not make one a participant in a conspiracy unless he acts or fails to act with knowledge of the purpose of the conspiracy and with the view of protecting and aiding it. And there is no genuine issue of fact or evidence beyond a reasonable doubt that Lindsay Marr, one of 239 scientists who had presented a request to the World Health Organization in June, and who has appeared multiple times in the press to advocate the position that the primary means of transmission for COVID-19 is via aerosol transmission, or particles measuring under 5 microns that can remain suspended in the air for up to 2 hours, even after the person infected has left, did fail to respond to our inquiries regarding what is apparent on all empirical facts, that COVID-19 can only be deployed as a biological weapon of terror, lacking sufficient capability for infection through casual social contact, and invalidating the use of social distancing, as well as the wearing of non-medical grade personal protective equipment, as established empirically by a gold standard study conducted by the National Institute for Occupational Safety and Health over a decade ago under the Obama administration. There is no issue of material fact on all evidence of record, beyond a reasonable doubt that Justin Wilson, the mayor for the city of Alexandria, did ignore this gold standard study regarding the effectiveness of non-medical grade PPE, even after being told specifically in litigation, and did, under the guidance of Dr. Northam, solicit the over 160 Christian churches in the city of Alexandria to assist in the manufacture of the same facial coverings known to provide no protection at all, and for the specific reason to provide to persons working in hospital settings who could not afford medical grade protection. Deplorable. And there is no genuine issue of material fact on all evidence of record beyond a reasonable doubt that even after receipt of a sworn affidavit regarding the same, Commonwealth Attorney for the city of Alexandria, Brian Porter, did fail to even investigate the matter. And there is no genuine issue of material fact beyond a reasonable doubt that Mayor Justin Wilson and the city of Alexandria did, most recently in the circuit court, filed pleadings to assert that they were not responsible because they were only following orders. Moreover, there is no genuine issue of material fact on all evidence of record beyond a reasonable doubt that Senator Mark Warner, a resident of the city of Alexandria and ranking Democrat on the Senate Select Committee on Intelligence, did receive in March an intelligence estimate to alert him of the fact that even in migration from China, the pandemic pathogen alleged to cause the disease of COVID-19 was proceeding upon a path that appeared not to be described as a natural one for an unintelligent pathogen under an epidemiological model, randomly seeking human hosts, but rather was consistent with a biological weapon of terror being deployed based upon tactical and strategic considerations, facts validated in Wuhan against the farming population, against Americans traveling aboard the cruise ship Diamond Princess, facts validated by the flight crew and reactor personnel who appear to be targeted, according to all sick call reports reviewed by the United States Navy aboard the USS Theodore Roosevelt, with a pathogen where there is no evidence that it had come aboard the aircraft carrier on a human host walking up the gangplank in Da Nang, Republic of Vietnam, nor through any passengers being ferried by helicopters from the Philippines, and countless other case study examples, including the Chinese restaurant example presented by Lindsay Marr and 238 other scientists to urge the World Health Organization to modify the transmission threat model for COVID-19, which has been attributed to the deaths of over 5,000 residents of Virginia, all living in fear, unnecessary fear of an invisible enemy they had been led to believe by doctors was a highly contagious pathogen, a conclusion supported by no medical evidence, and over half of whom were the elderly in nursing homes, now desperately seeking a vaccine to save them, a demographic known to be vulnerable from the very beginning of this public health crisis. And as presented in an affidavit to the Fourth Circuit on the same day that Dr. Northam suddenly announced that both he and his wife had been infected, if COVID-19 can only be deployed as a biological weapon of terror on all empirical scientific evidence, the president and his wife, as well as any other persons, including children in grammar schools and high schools, as well as the up to 30 Secret Service officers infected with the president, could only have been victims of an act of transnational terror in conspiratorial cooperation by Dr. Ralph Northam, who even throughout the illness of the president made public statements contrary to all known medical facts about COVID-19. As stated by the Supreme Court in the case against General Aaron Burr for treason in 1807, if the gentleman had believed this decision to be favorable to him, we would have heard of it in the beginning of his argument. For the path of inquiry in which he was led him directly to it. Interpreting the American Constitution, he would have preferred no authority to that of the Supreme Court of the country. Yes, sir, he would have immediately seized his decision with avidity. He would have set it before you in every possible light. He would have illustrated it. He would have adorned it. You would have seen it under the actions of his genius appear with all the varying grandeur of our mountains in the morning sun. He would not have relinquished it for the common law, nor have deserted a rock so broad and solid to walk upon the waves of the Atlantic. But he knew that this decision closed against him completely the very point for which he was laboring. Hence it was a decision was kept so sedulously out of view until from the excluded materials of the common law he thought he had reared a Gothic edifice, so huge and so dark as quite to overshadow and eclipse it. Let us bring it from this obscurity into the face of day, we who are seeking truth and not victory. Whether right or wrong, have no reason to turn our eyes from any source of light which presents itself, and least of all from a source so high and so respectable as the decision of the Supreme Court of the United States. My name is Major Mike Webb, and by God, I am running for governor of Virginia. I ask every Christian, every conservative, every Republican, every Democrat, every liberal, every conservative, and every Virginian and American true to like the motto of the imagery. Follow me and we shall overcome. Honest. And y'all come back now. Yeah. This advertisement was authorized by Mike Webb.